All right, today we're diving into something really fascinating. It's a case study of a legal document, but trust me, it's so much more than that. We're looking at an appellate brief written by a homeowner, all by himself, that is basically a masterclass in how to fight back against the foreclosure system. This isn't just about one person's struggle. It's a deep look into legal strategy and how one person might actually be able to change the rules of the game.
So, at the heart of all this is a homeowner named Jeremy Bass. And this quote from him really tells you everything you need to know about what's at stake. You can feel it, right? For him, this wasn't just some abstract legal fight. This was about his entire life, everything he'd worked for, and really just a demand for a fair shake.
So, you might be asking, why was this guy arguing his own case in front of the state's highest court? Well, this number is why. 125. That's how many law firms turned him away. Think about that. Most of them cited conflicts of interest, which points to a huge problem in the system. The very firms that are best at fighting foreclosure cases are often already working for the other side.
So, this situation turned him into what's known as a perforce pro se litigant. That's a fancy term for someone who's representing themselves not because they want to, but because they literally have no other choice. And that sets up this classic David versus Goliath battle. It also brings up some really deep questions about fairness and what the justice system owes people it has basically locked out from getting a lawyer.
Okay, so let's get into the weapon Bass created for this fight, his 47-page appellate brief, which he filed with the Idaho Supreme Court on June 12, 2025. And honestly, what he managed to put together absolutely stunned legal observers.
I mean, just look at these numbers, 47 pages. He raises 16 different, well-argued legal issues, and he backs it all up with over 50 legal case citations. This is the kind of work you'd expect from a whole team at a big law firm, not from a first-timer going it alone. It's just staggering.
And it wasn't just a few people who were impressed. Legal experts took notice right away. Professor Eleanor Blackwood called it genuinely unprecedented, and I love this part of her quote. She said he hadn't just learned the rules, he had learned to think like an appellate advocate. That's a whole different level of understanding. He knew how to spot the key issues and frame them perfectly for an appeal.
So, how did he do it? This wasn't just a laundry list of complaints. Nope, it was a carefully planned, three-pronged attack on his opponent's entire case. So let's break down his strategy.
All right, his first line of attack was an absolute masterstroke of legal tactics. He found a critical case-ending error, but not in some dusty document. He found it in the other lawyer's own words, spoken right there in open court. He called it the smoking gun. And the legal tool he used to do this is called a judicial admission. Basically, it means that when a lawyer says something on the record in court, it becomes a binding fact. You can't take it back. The argument is over on that point, it's locked in.
And this was the statement. This was what the opposing counsel said. Now, Bass's argument was brilliant. He pointed out that for a judge to just end a case with something called a summary judgment, there can be absolutely no dispute about the facts. So he argued that this statement, disagreements over how we view the facts, was a conclusive admission that factual disputes existed, making the summary judgment legally impossible.
Okay, so that was attack number one. For his second move, he zoomed out. He went from this one critical error in his own case to showing a much larger, much more troubling pattern of behavior. He was arguing that what happened to him wasn't a one-off thing at all.
He laid out the evidence. He pulled records from 9 other cases in Utah, and a really disturbing pattern started to emerge. You see the same names popping up over and over again. The same companies were winning property auctions that were run by the very same law firm that would then represent them in court later. It looked way too cozy.
And then he put a number on it. He actually did a statistical analysis. He asked, what are the odds of the same bidder winning 12 foreclosure auctions in a row? The answer? 1 in 244 million. His point was clear. This wasn't luck. This was compelling evidence that the auctions were being manipulated. And then we get to the third and final attack. And this one? Well, this one was a bombshell. It wasn't aimed at his opponent. It was aimed squarely at the judge presiding over his case.
So here's what Bass brought to light. The judge in his foreclosure case was the very same judge who had presided over his difficult divorce years earlier. That previous case involved deciding who got the exact same property, and it required her to make judgments about Bass's credibility. He argued that her failure to disclose this history and step aside created, at the very least, a massive appearance of bias.
Now, this is so important. He didn't just call this a mistake. He called it a structural error, and that's a very specific legal term.
It means a defect in a trial that is so fundamental, so corrosive to the whole process, that it can't be fixed. It's not a harmless mistake. If the appeals court agrees it's a structural error, it requires an automatic reversal of the decision. Period.
But here's where it gets even more strategic. Bass wasn't just trying to win his own case. In a really savvy move, he asked the Idaho Supreme Court to answer 6 certified questions. This is a tactic designed to push the court to make new law or clarify existing law for everyone. His first question gets right to the point. He's basically asking, can you use a legal technicality, a procedural rule, to rubber stamp an outcome that is at its core based on fraud? It's a question about rules versus what's right.
This next one, well, it's personal. It gets to the heart of his situation. He's asking, do people who are forced to represent themselves, like he was, get any kind of leeway from the system? Or are they expected to know the law just as well as a trained attorney with years of experience?
And finally, he asked this fundamental question about due process. When your home is on the line, are you entitled to a full hearing where you can present all your evidence? Or can your home be taken away through a shortcut summary process? It's about the right to truly be heard.
So what's the big takeaway from all this? I mean, regardless of how the court finally rules in his specific case, this one document, this brief, has already created a powerful legacy of its own.
And Professor Margaret Thornton really nailed it here. She said this brief is going to circulate. It's become a playbook, an open-source template for other lawyers, and especially for other homeowners who are fighting these battles. It's a roadmap for how to do it right.
And get this, the lower court judge had dismissed Bass's defense as frivolous. But here's the kicker. The lawyer for one of the other companies involved in the case actually said on the record that Bass's arguments were logical and sound. You couldn't ask for a more direct contradiction. It's just powerful ammunition for his appeal. And in the end, this whole incredible story about Jeremy Bass and his brief leaves us with one really big question to think about. If the system itself puts up so many barriers that you can't get a lawyer, then who is left to stand up and demand that justice is actually served?